This is part one of a three-part lecture series for Module 1. Our part one is the criminal justice system and the criminal law in the United States. The origins of the criminal law in the United States is based upon the concepts that are found in our criminal law system. These concepts come from legislative enactments at the federal, state, and local level, court decisions at the federal and state level, administrative rules, and executive proclamations at the federal, state, and local levels. The origins of law go all the way back to ancient law, where your first known written laws were found on the tablets at Ur, and it has been determined that these tablets are over 5,000 years old. But the first codified system of laws that define criminal acts and penalties is what's known as the Code of Hammurabi. King Hammurabi of Babylonia ruled from 1792 to 1750 BC. His code consisted of about 282 laws, and they range anywhere from how to conduct business, prices of goods and services dictated for particular professions, and even delved into family law, including laws on marriage, divorce, and inheritance. As I stated, the laws within the code define criminal acts and penalties. If you act, you were responsible for serving this type of penalty or paying this type of fine. The Code of Hammurabi is significant because it influenced the laws of other cultures throughout time. Of course, being an English colony, the youthful America adopted what's known as the English common law during its early years. And our code to this day is somewhat derived from England's legal code. So common law began under William I, also known as William of Normandy, William the Conqueror, when he created what's known as the Eyre. The decisions by the judges of the Eyre became the foundation of English common law. And the early focus of English common law was not on what one person did to another, but were these violations a violation of the king's peace. The interpretation of the common law led to eventually categories being established within the common law for violations like homicide, robbery, arson, and assault. And then soon thereafter, as Parliament established and asserted its own power, Parliament began to add crimes to the common law as well. As I said earlier, 13 colonies in America adopted the English common law, but also in this continent, you had French territories and colonies that adopted the Napoleonic Code, as well as Spanish colonies that adopted the Spanish rule of law. The law in this country developed separate from English traditions and common law. The American system of justice, the criminal justice system and criminal law, is based upon statutory law. And these are the laws that are created by legislative bodies at the state level and the federal level. So common law as it exists today in the United States is the system of laws that are derived from judicial decisions rather than legislative act, as well as the laws that remain intact from colonial America and England. So we have two systems of law in the United States, the first being the criminal law and the second being civil law. Under criminal law, most criminal laws are statutory, and violations of those laws are called crimes. Crimes are violations of public rights and duties that create some harm to the community. They affect the entirety of the community and therefore are punished by the community. And within the civil law system, these are matters between individuals, especially in terms of personal injury, property disputes, contractual disagreements, or administrative violations, as opposed to violations of the criminal law, which are called crimes. Violations of the civil law are called torts. And the remedy for a civil tort violation is not a penalty, it's not jail time, but it's payment for damages. And it's important to note that the same act can be considered a crime and a tort simultaneously. So in the early 1800s, the American criminal law system underwent a series of reforms as a proponent of Jeremy Bentham's reforms. This reorganization included organizing crimes according to the amount of social harm caused. Until this day, American state penal codes have been adopted and continue to be adopted within the Bentham approach. It's important to note that the purpose of criminal law is to prevent and control crime by sanctioning behavior. So there's some important questions that we have to consider. What conduct do we sanction? Is this debate on criminalization or decriminalization? There's no question amongst most people that criminalization of crimes such as assault and burglary, robbery, rape, and murder are appropriate. But it gets a little bit more murky and confusing when you talk about offenses that are meant to protect public morality, such as drug laws, especially in the area of marijuana usage, crimes like associated with gambling and prostitution. Who should be sanctioned? And we all agree that those that intentionally violate the law without any type of excuse or justification should be sanctioned. And then what type of sanction do we impose? The type and the amount of punishment. Does the punishment for a crime entail just paying a fine? Does it entail a short jail sentence? Does it entail a longer prison sentence? Or ultimately, does the sanction for a crime need to be the death penalty? Within our system of criminal law, there are two types of criminal law. The first is substantive criminal law. These are the laws that are created statutorily by legislative bodies that define criminal conduct and the punishment for committing the criminal act. In terms of substantive law, the mental and physical liability components of that act have to be identified and proven. The second type of criminal law is procedural criminal law. These are the methods in which the prosecution of the defendant proceeds to enforce the substantive law. So we're talking about elements of the criminal justice system like law enforcement, prosecutors, and of course the court system. There are 5 elements to a crime that need to be proven for the accused to be convicted of a crime. First, there has to be a willful act, or what's known as the actus reus. Second is the guilty mind, or mens rea. This is the intent to commit the act that the law prohibits, not the law itself. There must be a concurrence of act and intent. The mens rea has to proceed or occur at the same time as the actus reus. There has to be harm to a person, property, or to society in general. And then a causal relationship between the criminal act and the harm. Did the offender's actions lead to the resulting crime, which is the harm to the person, property, or society? Within our system is this principle of legality, and it's an important component of our criminal justice system. The principle of nullum crimen sine lege, nolo poene sine crimen. No one can be punished for an act not defined as criminal. The act was committed before the act was committed. There's 3 requirements: that the statute should be understandable to a reasonable person. The statute should not delegate policy matters to the police, judges, and juries to resolve as they see fit. There should not be an area of subjectivity given to the proceedings. And ambiguous statutes interpreted by judges should always benefit the accused. In terms of legal precedents and manners in which statutes are derived, one avenue in which states often look toward to guide statute development, penalty development is what's known as the modern penal code. In 1931, the MPC was proposed by the American Law Institute as a model penal code for the states in the United States. But at the time, the nation was going through the Great Depression, so there was no funding for instituting the model nationwide. In 1950, a grant from the Rockefeller Foundation for the project was granted, and the project was reignited in 1952. So 13 drafts later, the grant writers and reviewers and lawyers working on the model penal code proposed an official draft, which was published by the ALI in 1962. What the model penal code did was it recodified principles of criminal responsibility based on the existing source of criminal laws in our country. The intent of the model penal code was to be a systematic reevaluation of existing criminal laws in the United States. It was no intent to be a uniform criminal law for the US or adopted in entirety in any state. The result of the model penal code was that the majority of states has revised their codes in line with the model penal code. In terms of federal criminal law, in a pre-Civil War America, the manner in which federal criminal law was defined and punished was held within the states. Post-Civil War, you had this federal overlap of state laws. Of course, the Constitution limits the power of the federal government, including how it goes about defining and prosecuting crimes. And in fact, the federal crimes of treason, counterfeiting, against the laws of nations, and laws on the high seas are the only laws that are stipulated in the Constitution. All other federal crimes comes from the US Congress's ability to pass laws and to implement powers at the federal level. So for example, Congress has enacted criminal laws related to civil rights, mail, commerce, drugs, extortion, of course, organized crime, and racketeering. Within the American criminal justice system, there are three views of the system. One, that it's a social system. Two, that it's a body of legal rules. And three, it's an administrative system. In terms of being a social system, criminal justice encompasses the legislative bodies that enact the laws down to the citizens that are required to obey those laws. As a body of legal rules, criminal justice encompasses all the laws, rules, and procedures that affect the criminal law. This includes things like legal precedents and judicial opinions. And then finally, as an administrative system, criminal justice is a method for enforcing criminal law. This means the law enforcement personnel, prosecutors, defense, the court system, and correction system that make up the administrative system within criminal justice. Law enforcement, of course, we know is the police departments, sheriff's offices, state police agencies, and other state agencies that investigate crimes across our country. There are four basic functions of law enforcement in the United States. Number one is prevention, and this is carried out through the patrol function of a department to detect crime. Number two is patrol officers initially respond to matters that need investigation, and then detectives perform the investigation in certain cases or through department policy. The third basic function is detection, And these detection activities may be conducted by specialized units like narcotics, impaired driving units, computer crimes units, and forensics units. And the fourth basic function of law enforcement is court preparation. This is the manner in which law enforcement officials go about collecting and preserving evidence, drafting reports, reviewing scientific analysis, and reviewing other reports. At the federal level, law enforcement is conducted by agencies like the FBI, the DEA, ATF, US Marshals, and elements of the Department of Homeland Security, like the Secret Service, Customs Border Protection, Immigration Customs Enforcement, and others. The second part of the American criminal justice system is the prosecution and defense. Our system of criminal justice in the United States is what's known as adversarial. We have a prosecution and a defense, and they are rival parties in the process. The prosecutor receives the case from law enforcement and decides whether to pursue charges, and then tries the case through adjudication, meaning a trial by verdict, guilty plea, or dismissal of the case. The district attorney, or some similar title, is the chief prosecutor at the county or parish level. Most DAs are elected, but some are appointed by the particular executive in their jurisdiction. The attorney general is the chief prosecutor in the federal system, and the AG is appointed by the president. Under the attorney general are U.S. attorneys, and they are the chief prosecutors in the 94 federal districts across the country. And the U.S. attorneys are also appointed by the president. As part of the adversarial system, opposite the prosecutor is the defense attorneys. The defense represents the accused from the interrogation through trial. The right to counsel is a fundamental amendment to the U.S. Constitution. And of course, a defendant may hire their own attorney or have an attorney appointed to represent them from the public defender's office. The third part of the American criminal justice system is the courts. We have a dual judicial system in the United States, meaning we have courts at the state level and at the federal level. Within the court system, there must be jurisdiction. This is the scope of the court's power or authority to act on any case before that court. Federal court jurisdiction means that they hear prosecution of matters related to federal criminal offenses. Federal trial courts are in each state. There are 13 federal courts of appeal, and of course, the U.S. Supreme Court. State courts hear prosecution of matters related to state criminal offenses. Each state has its own court system, but generally, each county or parish has trial courts and juvenile courts. Each state has an appellate court and a Supreme Court. At the local level, you have what's known as municipal courts or justice of the peace courts in some jurisdictions. Courts operate according to the 14th Amendment, and the Due Process Clause has been applied to the states as well. Violations of the 14th Amendment can be subject of the state appeal or federal habeas corpus claims. Habeas corpus means there's a writ to secure a person's release when detention is unlawful. The 14th Amendment covers the right to trial by jury, right to counsel, that defendants are presumed innocent, there's freedom from unreasonable search and seizure, right to remain silent, right to compel witnesses at trial, right to a speedy trial, freedom from double jeopardy, freedom from cruel and unusual punishment, and freedom from discrimination. The fourth component of the American criminal justice system is the correction system. These are your institutions like jails and prisons. Jails are used when defendants are incarcerated pending prosecution, are serving short-term sentences, and are generally operated at the city or county or parish level. Prisons have various levels of security, including minimum security, medium security, and maximum security prisons. And they also operate juvenile prisons at the state level. Prisons are operated at the state and federal levels of the criminal justice system. Agencies involved in the corrections process are what's known as probation and parole agencies. Probation is the investigation and pre-sentence phase in the court process. Probation officers will draft investigatory and pre-sentence reports and provide them to the courts. Probation officers supervise probationers after their release. Probation is often frequent for first offenders, where the first offender will not get jail time. They'll be sentenced to probation only, with the requirement that they report to their probation officer and refrain from criminal conduct. Parole is a part of the state correction system. This is a release of incarcerated persons before completion of the sentence. There's a requirement that parolees report to their parole officer and refrain from criminal conduct. And any violations may lead to reincarceration to complete the sentence. Also within the correction system falls community corrections programs, things like drug rehab centers, halfway houses, and community service programs. The American criminal justice system operates under the principle of federalism, where power resides within the states and the District of Columbia. In terms of the authority of law to take a person under custody, we know that to be what's called arrest. To arrest someone, a law enforcement officer must have probable cause, which means they have reasonable grounds or probability that the suspect committed the crime. An arrest can take place with a warrant showing probable cause to a judge, or without a warrant when the crime is committed in the presence of an officer, when exigent circumstances exist, or following the pursuit of an offender after the law has been broken. Not all arrests result in prosecution. The decision to prosecute lies with the prosecutor himself or herself and within the court system. There are pre-trial procedures prior to trial. A defendant can be released on recognizance, which means they make a promise to appear. They can be released on bail, which is a deposit of cash, property, or bond guaranteeing appearance. The second portion of pretrial procedures is the charging of the crime, filing of the charge by the prosecutor. This is where the prosecutor makes a decision to pursue the case. The next procedure is preliminary hearing by a judge to determine if probable cause exists. This is an important first step for law enforcement in the case. If it's a misdemeanor charge, the defendant can enter a plea. If the defendant enters a plea of not guilty, the case moves to trial. Under felony charges, a defendant has to be indicted by a grand jury or a bill of information issued by the prosecutor. A grand jury is a panel selected from the electorate to review criminal investigations in order to decide if criminal charges should continue or be brought. A bill of information is a written statement of the formal charge by the prosecutor. The next step in pretrial is their arraignment and plea. This is the appearance by the defendant to respond to the formal charge that has been issued either by the grand jury or by the prosecutor's bill of information. This is where the defendant enters a guilty plea or a not guilty plea. After arraignment, the defense and prosecution can go through what's called a plea bargain process. Plea bargains resolve a majority of the cases before they even go to trial. Plea bargains save time, of course. They save money for prosecutors and also for the defendant, and may result in a lesser charge and penalty for the defendant. A case can be dismissed on three bases of defense: that the crime is not a violation within the jurisdiction, the facts don't constitute the crime, and a reasonable jury would not convict on the basis of the evidence that's submitted. Post-conviction procedures within our criminal justice system includes sentencing, which is where a judge sentences a defendant to a particular amount of time of incarceration, or paying a fine, or serving probation. Mandatory sentencing guidelines are often imposed, or a sentencing hearing can be held by the judge. Sentencing is done in accordance with the range within laws that are drafted by the different legislative enactments. And in the case of death penalties, sentencing leads to a second trial. Another post-conviction procedure is the appeal or discretionary review. There are 4 possibilities for appeal on substantive grounds. These are: the charge of conviction is not a crime, the evidence was not sufficient to support a conviction beyond a reasonable doubt, and not all elements of the crime are alleged, or that the jury was improperly instructed. Appeals may be undertaken on procedural or evidentiary grounds. A writ of certiorari is a written order from the U.S. Supreme Court to a lower court for that lower court to provide records on a case for review. The last post-conviction procedure is post-conviction relief. Habeas corpus relief requests can be made to the appropriate federal or state court when all other appellate options have been exhausted.